Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome to our Curious Amalgam. I'm Jaclyn Phillips, and today I'm here with Saverio Valentino, board member of the Italian Competition Authority. Welcome back to the show.
Thank you very much, Jaclyn. Great to be here.
Yeah, we luckily got to speak last year, so now we have part two. And since you and I last spoke, the Italian Competition Authority has been pursuing a lot of important initiatives. So tell us what success has looked like for your agency over the past 12 months.
Of course. Thank you for your question. The last year, 2025, has been a very significant year for the Italian authority because we completed 15 investigations, 5 of which concerned mergers, phase 2 mergers that we cleared subject to conditions. And in 6 cases, there was a finding of an infringement of competition law. And for this reason, we issued fines for 1.4 billion, which is quite a significant amount. Then we had already 13 ongoing investigations when we entered into 2026. We completed already four of these investigations. One was a merger, also cleared subject to remedies. In two cases we accepted commitments, and in one case that we completed last week, we ascertained an infringement, a violation of Article 101, so an anti-competitive agreement. The interesting fact is that this anti-competitive agreement concerned a vertical relationship, so vertical resales like resale price maintenance, which I know in the US is seen as less serious, while in Europe is considered an hardcore restraint.
Got it.
I think that the main the cases that are more interesting to talk about are cases concerning the digital sector. We talked about this last year, about the entry into force of a Digital Markets Act, and whether the Digital Markets Act would leave room for intervention for national competition authorities. The 2 cases of which I'm going to talk are an example of the possibility for national competition authorities to intervene. One case concerns Apple. For its ATT policy, that is to say the policy put in place by Apple to ensure that they comply with the data protection rules, the European data protection rules, which are extremely tight, let's say. So Apple, for its own apps, was showing a single prompt to ask for the consent of the user. By contrast, for the apps developed by third parties, was asking for two prompts. One, its own prompt, and then the prompt of the app. So there was this sort of discrimination that reduced the engagement that third-party apps could have with their users, and the possibility to show them advertisings that were more suitable to the preferences of each user. The peculiarity of this case is that there were investigations by 5 different national competition authorities in Europe. The French Competition Authority was the quickest one in completing its investigation, and it fined Apple 150 million for abuse of dominant position. Then last December we issued our decision with a fine of 98 million, almost 98 million. By contrast, I know that the German Competition Authority are trying to close this case with commitments. Then there are the Polish and the Romanian authorities that have also their own cases. We have been in constant touch with our sister agencies in other European member states in order to coordinate and to try to find a common solution, because the issue, the relevant issues were the same. And now particularly we are in touch with the German authority, because the solution that they are going to find for their commitments may be the good solution in order to ensure compliance by Apple to our decision, to our injunction to stop the infringement. The second case that I would like to mention instead concerns Meta. It's another example of cooperation, not among authorities of the different member states, but between the Italian authority and the Commission. All of us have used WhatsApp, and we know everybody noticed that at a certain point we had the icon of Meta AI appearing on WhatsApp. And we initiated an investigation last July because to determine whether the presence of Meta AI in WhatsApp, which was not solicited by users but was a unilateral decision by Meta, could amount to an unlawful tying. Meta was relying on its dominant position in the instant messaging market in order to push its position, to improve its position in the AI chatbot market. In Europe, WhatsApp is really by far the most important messaging app.
Yes.
I know that here in the US it's less important, but in Italy in particular, it is incredible how important is the use of WhatsApp. Nobody sends SMS, everybody sends WhatsApp.
Yeah.
So, of course, we initiated this investigation with after discussing with the European Commission, so everything was done in full cooperation with the European Commission. But the case gets interested afterwards because in October of last year, October 2025, Meta decided also to stop, to ban from WhatsApp competing AI chatbots. The decision was had immediate effect for those AI chatbots that were not yet on WhatsApp. By contrast, for the 11 AI chatbots that were already on WhatsApp, the decision would take effect starting January 16th, 2026. And these chatbots included ChatGPT, Perplexity, and in particular several small AI chatbots that were really relying on WhatsApp in order to reach their users. So it was quite the mean of election. It was the means that they had chosen in order to reach their users. And this also because we found out that Meta encouraged them to use it in order to enlarge the number of users of each app. Also in this case there was close cooperation with the Commission, because the Commission was really interested in this case. They received a lot of complaints against Meta's behavior. However, they let us go ahead with the possibility to impose interim measures. This is because the Italian proceedings for the imposition of interim measures is much lighter with respect to the Commission. Much lighter, but still fully respecting the rights of defense of the parties. So the possibility to lodge a written submission, to be heard by the board of the authority and present their arguments. And so that we initiated proceedings for the imposition of interim measures at the end of November. In the beginning of December, the Commission initiated its own case against Meta for the entire European Economic Area, except Italy, in order to let us go with the possible imposition of interim measures, which we actually decided to impose just before Christmas. And afterwards, the Commission, at the beginning of February, so just at the beginning of last month, they sent a statement of objections to Meta for the imposition of interim measures for the rest of the European Economic Area. Meta tried to comply with our injunction by allowing competing AI chatbots on WhatsApp. However, they started to ask for a payment. So now the situation is getting trickier because while a payment may be justified, we have to determine whether the level of his payment is reasonable or not. So both the Commission and the Italian authority are asking questions to Meta and are discussing also with the interested third parties, because third parties stopped basically providing the service because they said that the cost would be too high. And so for the time being, I cannot say anything because the investigation is still ongoing. But this is, I think, an excellent example of a necessary cooperation that we have among European institutions, particularly with the Commission, and so let's see what will happen.
All right. Well, thank you. It's really interesting stuff, and hearing about kind of how enforcement in the digital sector has been evolving over the past year. Kind of similar theories we've heard, but new products, and I'm sure we'll see more. So you've clearly been dealing with a lot of investigations, busy already in the first couple months of this year, and there's been a lot going on in the digital sector. But what can we expect your agency to be really focusing on as we look towards the next year? Do you have any key enforcement priorities?
As for any competition authority, I think the most important priority should be the fighting against cartels. So for this reason, I think I mentioned it last year, the Italian authority introduced a whistleblower platform that allows to interact with people that want to keep their anonymity, even with the authority, so by sending encrypted messages. And this whistleblower platform, I think since the beginning of the program in 2023, we have received more than 600 complaints, only 100 of which were taken seriously into account and investigated a bit further. And the interesting issue is that these complaints do not only concern cartel, even if the platform was introduced for cartels, but do not only concern cartels. They may refer to other violation of competition law. For instance, the decision that I mentioned before concerning resale price maintenance started with a communication by a whistleblower. And the peculiarity of this communication concerning resale price maintenance is that after we started the investigation into this Italian jewelry and watch company, we received several more complaints concerning resale price maintenance. So our investigation, the fact to make them public, encourage people to come forward to the authority and provide us more information. And also, the whistleblowing platform has been useful for another, the other core business of the authority, which is consumer protection. So we started at least one case based on information received from a whistleblower, and we closed it. By fining the company. However, probably the most interesting case that I would like to mention that came thanks to the whistleblowing platform, it concerns a possible no-poach agreement. I know that you, in America, you have been at the forefront in the fight in the application of competition rules to the labor market. I think the first case by the DOJ dates back to 2011 against the big tech companies that agreed not to poach the employees of each other. We have in Europe. They started with no poach cases a bit later. I think the Commission closed its first investigation ascertaining a cartel that included a no poach agreement in 2025 in the food delivery sector. By contrast. Not by contrast, but as far Italy is concerned, we started an investigation just last December, following a whistleblower complaint, into the market for the production of packaging machines. Automatic packaging machines. These machines need to be validated by specialized people, mostly engineers. And the complaint was that there was one company active in Italy that had an agreement with competitors and with other companies active at other stage of the value chain, so in upstream or downstream markets, in order not to solicit employees from the other companies. The goal of this kind of agreements it's quite obvious. If you cannot poach somebody in another company, the salaries are going to remain lower. So people will earn less money. That's why it's a very important field, and I'm happy that the Italian authority has started to investigate also this kind of issues, and hopefully, as it happened for the resale price maintenance, there will be many more complaints. Hopefully, there are no such agreements. First of all,
yes.
But if there are if there are such agreements in Italy, we would like to encourage employees to come forward to let us know whether there are these unlawful behavior by their employer.
It sounds like the whistleblower program has been pretty successful in bringing some of these issues that are maybe harder to spot to the forefront. So we'll be looking forward to talking next year and seeing what sort of things have come out of these investigations and what you're up to. So thank you very much for providing that update. And because you told us your interesting hobbies last year, and we learned about your love of music and concerts and DJs, I wanted to ask you, you've come to our lovely city of DC this trip. In the past year, have you taken any other fun trips around the world? Anything notable?
I think the best trip I had was to Brazil. I had been already a few times to Brazil, but this time I went to Brazil and I visited for the first time the Amazons.
Wow.
So I spent three days in the middle of a jungle. It was quite an experience. Then New Year's in Rio, and then an amazing, I went to a very nice island, Fernando de Noronha, with very beautiful beaches. So it was definitely a very good trip.
That sounds lovely. I have nothing to compete with that. I went to Phoenix, Arizona for a deposition. Okay,
definitely not. But although I want to say that Brazil is a wonderful country. I don't want to provide an advertising for Brazil. Italy is the most wonderful country because we have beaches, beautiful beaches like in Brazil, but we also have the mountains where you can ski, and more importantly, we have our cities with all the art there. So my promotion is for Italy in this case.
I think it would be difficult for you to find anyone who disagrees with.
Thank you so much.
What you're saying about Italy. Well, thank you so much. We truly appreciate you sitting down with us and letting us know what the Italian Competition Authority is up to, and we'll be watching closely, and hopefully we'll be chatting again next year.
Hopefully, yeah, for sure.
Thank you very much.
Thanks a lot to you, Jaclyn.
Hello, and welcome to our Curious Amalgam. I am Jeny Maier, and I am being joined yet again by one of my favorite guests, President Nuno Cunha Rodrigues, the head of the Portuguese Competition Authority. And we're very excited to have you back on our Curious Amalgam. Thank you for being here.
Thank you, Jeny. It's my pleasure to be here with you once again.
Yes.
It's becoming to be a tradition.
It is a tradition.
Side, right?
Yeah, we're very excited to hear what has been happening in Portugal. Why don't you tell us about some of the highlights from the agency in the past year?
Well, I'll start by the great news is that the Portuguese authority received a good rate according to the GCR. So we were ranked one of the 6 best authorities worldwide, which is good for, I would call it a medium jurisdiction, like Portugal. We are a medium-sized country. And so we are on the same, I'll say, level as the Brazilian authority, as the European Commission, as Germany, so much bigger than we are. So I'm very proud of the work that we've been doing at the Portuguese authority. So in terms of highlights and moving to this year, this current 3 year, we have already adopted 5 sanction decisions. We are very active when it comes to labor markets, and we are known for our work in terms of labor markets. And once again, many of these sanction decisions that were taken this current year are related to labor markets. So we have, among others, a case related to a horizontal agreement in the IT sector. It was based on a whistleblower. And then we found that 4 companies that perform in the IT sector were involved in this no-poach agreement. And one of them, the case was closed by a settlement agreement, and then 3 of them moved to the court. And actually the court will come up with the decision this week, on the 27th March in this case. So we have another one related to concerted practice. It was a case based on exchange of information in terms of labor conditions, referring to not only salaries but other conditions that employees have. And then we have an interesting case on an abuse of dominant position case that happened in the autonomous region of Madeira, which is an island in Portugal. It was in the agricultural sector, and it started because we made a market study in that area. That led us to this case, to this abuse of dominant position case that also closed based on a settlement agreement and commitments that were defined by the authority. Another decision that we took this year was related to association of undertakings in the tourism sector because they define minimum fees for its members in this case. So again, many things happening. Many of them in the context of labor markets, but also we have, of course, ongoing investigations that I cannot talk about. In terms of merger control, last year it was another year where we break a record. We had a record number of 100 final decisions that were taken by the authority. Among these cases, these 100 cases, we opened 2 in-depth investigations. We also conducted 9 investigations in terms of gun jumping cases, and I can refer to this later because now we have a new platform that helps us to detect gun jumping cases that it's based on AI, so I can talk a little bit on this later. And in the current year, we have already issued 19 final decisions, 18 under phase 1 and 1 into phase 2. The one that was approved in phase 2 is a very interesting one, because it was related to a merger between the biggest private healthcare group in Portugal. So they have several hospitals in Portugal, and they wanted to buy a group of hospitals in the south of Portugal to merge. So at the end, we approved the merger, but with several commitments, namely a commitment that is interesting, that according to this commitment, they are obliged to create a new hospital, to build a new hospital, and at the end to sell that new hospital to a competitor.
Very inventive kind of remedy.
Right, right, that's the point. It's kind of a commitment of investment/disinvestment.
Get the benefits of the investment and the benefits of having a structural remedy too.
Yeah, right. But also we have behavioral commitments that were decided in this case, such as a limitation of price increases for non-insured patients, maintenance of the current commercial terms with insurers. There were some problems of, vertical problems with the insurance companies. and the set of transparency, reporting and monitoring obligations that will remain to force until the full implementation of the disinvestment commitments, and this will happen most probably during 3 or 4 years. So we think we've helped to introduce more competition in the healthcare sector in Portugal, which is very important to us,
yes,
because they really affect consumers. So this is in the merger control side. Also, when it comes to the advocacy side, we have much work being done. One of them, I'm proud of the role that we've been doing in terms of learning and mapping the AI sector and to understand the interplay between competition and the AI sector. So we started this in 2023 with an issues paper that came out, I think it was in October 2023. And after that, we decided to publish what we call a short paper series that make a specific analysis on some of the aspects where competition can be harmed in terms of the AI sector. So we already published one short paper on AI and labor markets, another one on AI and access to data, another one on open models, and just recently one on AI and chips. And we are planning to do another one, and I can tell you this firsthand, that we are already working on a new short paper series that most probably will come out, I would say, in the next 3 or 4 months. Which, again, and I can tell you this firsthand, will be probably related to the role of the agentic AI, which is really something that has to be seen carefully by the authorities, because I think agentic AI will change the way that consumers behave. So we should first understand how it impacts on competition. Also, the work that we've been doing in this context of the AI is being followed worldwide by other authorities, and we've been trying to work with them hand in hand so that we can save resources and share our knowledge with other authorities. Another thing that we've been doing is trying to do some outreach initiatives in Portugal. I think it's important for authorities, for enforcers, to leave their headquarters and go and talk with people, with firms, with business, and understand their worries, their concerns, and explain somehow the benefits of competitions, the risks of infringement. So we've done that in the past with a campaign that I launched. It was called 20 Years, 20 Cities. And we aim to reach each of the most important cities in Portugal. And we partnered with the municipalities, and we did some conferences about the benefits of competition and the risks of infringement of competition. And it was interesting because during those meetings and those conferences that we did throughout the country, we received some tip-offs, about possible cartels and possible infringements that led us to the opening of cases, and we have even reached some final decisions about this. So it was interesting. And now we started a new campaign that is called Competition Plus, and it consists on a series of sectoral seminars that are targeted to both public and private institutions that are relevant to the national economy. So the sessions aim to promote the benefits of competition, clarify the rules on harmful behaviors, and highlight ways to react to potential anti-competitive conduct. And in particular, these sessions are very focused on practices such as bid reading in public procurement, decisions of business associations, anti-competitive behaviors in labor markets, of course, as well as the intersection between sustainability and competition rules. So we issue some guidance in this context about the interplay between competition and sustainability, which is, I would say, a new trend also in competition that helps business to understand what they can and they cannot do in this context. So also in terms of advocacy, we have done a lot of work. For example, we are looking carefully for the new directives on public procurement that will come out from the European Union. After 12 years, the directives will be revived, and there's a huge interplay between public procurement and competition laws, so we are also looking for this. In terms of internal aspects, and Jeny, stop me if you want, I don't want to monopolize our talk, but also we remain focused on keeping up with digital transformation. So we have been investing on the necessary tools to collect information, detect potential anti-competitive practices, and support investigations. So we have hired new staff. We are increasing our capacity in terms of human resources and also in technology. So we have developed 3 new platforms that maybe I spoke about them last year.
I think we talked about them last year. And
we like to label them, and we call it, the first one is the Scrap IT, which is used for web scraping. The second one is the Screen IT, which is now being enhanced, and it's used to, to perform interactively with the public procurement database and to extract information in order to detect bid reading cases. And the third one is the Detect IT, which I mentioned previously, and it's used for gun jumping.
Gun jumping, yes.
Yeah, and it helps us to open the 9 cases that I referred previously about this. We think AI has come, to change the work of the society and to change the way we work at the authorities.
That is really, it's been very interesting to hear from enforcers all over the world now that have shifted to use AI as a method to, not to supplement their human capital in trying to conduct investigations and detect, unlawful behavior. It was very, very interesting to hear that. Looking forward to this, upcoming year, do you have any particular new priorities? You've certainly been very, very active and well-deserving of the GCR recognition.
Well, there's one specific sector, we cannot forget, of course, the typical bread and butter cases that harm consumers. But one now in Europe it's quite important, I think, and we have to have a special look at it, which is the defense sector. National governments are spending lots of money in defense nowadays, and it's very important in terms of research and development, of innovation. Many of the products, for civil uses were created in terms of the military atmosphere. I refer, for example, for the microwave, what you have at your home, at your kitchen, to the GPS sign or to the internet that were created in a military atmosphere. And then they expanded for a civil purpose and civil use, benefiting from the externalities that produces. So we are looking carefully for the defense sector, and that's one of our priorities for 2026, to map the sector and to understand how it can impact and how competition is important for in this context. It's something that it's worrying also at the EU level. In the aftermath of the Draghi report, of the Letta report, of the competitive compass, now in Europe we are looking how can we help to foster innovation. And to foster innovation, you need competition policy and to make competition work. And that's our role also as authorities, is to make competition work, and namely in this context of the defense sector, where the impact in terms of the GDP that it's spent is so huge.
Yeah. Well, I was actually very interested in what you mentioned earlier about your trip all over the various cities within Portugal and interacting with regular consumers and business owners. What were some of the other things from that experience that surprised you or that you learned through the experience?
One of the amazing things that they didn't realize that regional cartels, local cartels, of course, they were an infringement of competition law and could be investigated and sanctioned by the authority. They said, oh, you are only based on the capital. We didn't know that you were coming here and that you wanted to know what's happening here. So it's good that you're coming. So it's good to create awareness among all the people, all the business, all the consumers, to have some information. And I'll say that all to the other authorities: leave your headquarters, go and speak to the people, and to understand their worries, their concerns. Because of course we can investigate and sanction anti-competitive practice, but we also can do our role as advocacy, and issue recommendations to our national governments to understand where are the bottlenecks, where are markets that are not working properly. And for that, we need to speak with people, with businesses. And that's the outreach initiative that we've done. I think we're very fruitful in that context.
Well, you've certainly done a lot of industry studies and market research and publications, and on top of your bread and butter day-to-day work, it's been a very exciting year at the Portuguese Competition Authority. So thank you for sharing all of that with us. As you know, being a frequent guest here on our Curious Amalgam, we like to to wrap up with a little bit of fun. And I think you've told us in the past about some of your other hobbies, but maybe what do you like to do here in Washington?
Well, I don't have much time. I will have to speak 5 times. I have meetings with my staff here, but I wanted to visit the Museum of Airspace next to the DC airport. I've never been there.
It's amazing.
I know. I wanted to see the space shuttle, the Concorde and all that. So I'm planning in my way back home to stop at the Airspace Museum and have a view at it, because I've never been there.
Oh, it's great. And if you can stop and see an IMAX movie at the same time, they've got some really fun ones there too.
Oh, I'll try to do that.
Good.
And I hope to see you, Jeny, in Portugal.
I would love to
know
return.
You've been there.
You've been a wonderful guest, and
you ate a lot of pastéis right? So.
Always good for some references for restaurants and dining. So if anyone here is visiting Portugal, to talk to this guy. Well, thank you very much as always. It's been a pleasure hearing about what has been going on in Portugal, and look forward to reconnecting next year.
Thank you, Jeny. My pleasure once again.
Thank you.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.